Speak to you today about the progressive notices of liability. uh, the videos and instruction uh, booklets that we put out with regard to the progressive NOLs has an error. We said that you can get a lien prejudgment on these claims that are formed on the basis of violations of your rights and loss of income due to constructive dismissal or or what they're calling leave without pay. So it seems that you have to get a judgment from the court for this type of debt. However, where it regards a debt for um, breach of your employment contract, whether you have a written one or not, doesn't matter. Like you, because you have the Employment Standards Act that governs um, like non-union um, employment contracts, and in there, there's no provision for an employer to put an employee on leave without pay. They can terminate them with or without cause, or lay them off. There's no provision for leave. There was, I think it was April 2020, the government passed uh, legislation that allowed employers to put employees on leave without pay if it was related to COVID-19. And it looked like they were protecting workers at that point because it was for uh, companies that were either locked down or they lost a tremendous amount of business because of lockdown, such as a brewery. So it didn't look that nefarious, but it just said due to COVID-19. So recently they started saying that they were putting them on leave without pay because they did not show their vaccination passport. But I want you to know that that legislation expired 6 weeks after the emergency um, order was revoked, which was June 9th. So that provision for leave without pay expired July 28th. So they can't use it. They could not use it between then and now. And so that's a clear violation of your employment contract if that's what they've done, put you on leave without pay. Or they changed it, like we did a Zoom that exposed that, and might be unrelated, but shortly after, we stopped hearing public statements that companies were putting, um, uh, well, not just companies, but companies and government programs and departments and so on, putting workers on leave without pay. That they stopped saying that. They all of a sudden started saying suspension without pay. But there's no category for that either. But they are saying that's for insubordination. So they're trying to get at least a dialogue going or a dispute going. But straight up leave without pay, boom, it's a clear violation. So if you have a clear violation, you can seek a default judgment from the court. That would be one that doesn't have to go through the whole process. I think they're challengeable. Like if the court gives you that, they can challenge it. But when you get that, you can place a lien. So uh, uh, that's still doable for your small claims at least. So any claim under 35,000. So you're looking at uh, losses in the amount. Well, actually, you're looking for losses like actual losses. So when you're in that category of leave without pay, you're looking at all the pay that's lost. But if they end up terminating you once you do push it, then if they didn't have cause, they have to pay. If you go by common law, it's 1 month for every year. But the labor board says 1 week, So if you go through that process and make a complaint to get a ruling, it's 1 week. Or if you go after them yourself through small claims, it's 1 month for every year. So I apologize for any inconvenience people faced by attempting to place a lien with a prejudgment. But you still have the effect of being able to pursue it as a debt and report to Equifax. And if you can get a prejudgment, if it's a loss of your wages, you can come back on it like that. And otherwise, I think we're looking good because they don't have that order on June 9th. I don't know why it was withdrawn. I have a suspicion of why, but I have no proof, so I don't want to say. But it's good that it's not there because a lot of the things that they're planning to do, they can't do. And it looks to me like and I don't know if they're going to try and correct that somehow, but the ROA was originally a regulation under the Emergency Management Civil Protection Act. And then when the order was withdrawn, they passed it into legislation, and its content doesn't have to, or its objective doesn't have to have an emergency to continue it. And the rationale they're using is that, okay, June 9th, no more emergency, but we still need like a gradual return to normal or whatever their verbiage is. So what you can see after June 9th, we never went backwards. Before, we were going ahead, like with ROA, you would go ahead and they had all these colors and stuff, and you'd pass into one color and then, oh, the cases are up, and you pass back. But since June 9th, it's only progressing forward, like opening up more. There's still a ways to go, but it's pretty normal now, except for the vaccination passports. I don't see that that uh, that has any legal basis to it. It's in Regulation 36420, but it doesn't look like there's any enforcement. I can't see what enforcement. And without an emergency, I don't know if they're going to be able to defend that at the end of the day. If anybody's moving forward with notices of liability and suing whoever, the employer or the business that's denying you all that, I don't think they're going to have much to rest on because no emergency since June 9th. So why are they forcing people to have vaccination? And then there's all kinds of other issues that go with the vaccination, such as no evidence that it stops the spread of COVID, transmission of COVID, or even stops you from getting it. And so they're saying, well, there's evidence that if you do have a vax, your severe symptoms are less likely. I don't even know if that's true. But even if it is true, that doesn't have anything to do with anybody else. Like if you're not spreading it, what the hell are they trying to force you to have it for? If you want to take the risk of the severe symptoms, which only a very small number of people get, and there's many doctors are putting out even research results showing that treatment with ivermectin dramatically reduces the death rate amongst persons who do become critical. Dr. Corey says 85% of those critical cases resolve within 24 hours. Not completely, he says, but it stabilizes, and then it still takes weeks after that to clear out the lungs and get you back to normal. But at least it brings you out of the critical state within 24 hours, and not in all cases, but in a vast majority. So, the idea of let's force them, and then of course there's all the issues of intensive reporting that of VAX injuries and severe VAX injuries. It just breaks my heart when I see those videos of people with the neurological reactions, where they're shaking and stuff like that, and they can't function. They have to have somebody look after them. Pfizer, several months ago, I think 4 or 5 months ago, they reported, actually it was CDC that reported that Pfizer had a 3% severe disability rate for vax injury, and it was at the level where these individuals needed somebody to look after them. So that like blew my lights. They still kept moving forward with that kind of statistic. So, I don't know. The whole thing doesn't make sense. And another thing, actually, Kelly Hale, who's a bar owner in Kingston, who they're just harassing because he won't do the mask requirement and he won't do the vaccination passport, because to do so would be breaking the law. And he said that, they're saying, and I agree wholeheartedly, you can't force me to break the law. Now, he says that he does not have to force vaccination passports for his staff. So that doesn't make any sense, because if you come into the restaurant and you show your Vax Pass, and then you come in, you sit down, you're not interacting with um, the other customers. Like their, tables are. I think they still even make them have it so far apart. But the staff is coming in and serving, and they're touching your glass and so on. So it makes no sense. It's such a high uh, response or reaction or whatever you want to call it to a situation that's not even an emergency, and then you have your ridiculous basis to it like that. So, yeah. So again, I apologize for misspeaking about the liens, but to correct again, you can uh, you can place liens, but it's only for construction debts and other debts that related to work or service to a property. Now, you can still get a quick lien by uh, attempting to get a default judgment from the court, and if you can get that default judgment, uh, you can file the lien right away. So then, if they challenge your judgment, it's still liened in the meantime. So, yeah, and all I can do is correct myself. I dealt with liens before, was construction liens, but I wasn't aware that you can't get a prejudgment lien, um, uh, basically well, I think you can also for, there's mechanics liens, but it's towards the car. Like you can keep the car and lien the car for any debt that, if like for repairs on the car or something like that. But regular debts, they don't allow it. And that's kind of weird, because, I mean, like there's all kinds of debts that are legitimate, and some of them are devastating. And there's even all kinds of other debts, business debts. So why would a construction debt be take more preference than any other kind of debt? So it's not, how do you say, it's not uh, logically conceivable that there would only be a narrow opportunity for debt. But you can try the default with employment. And what you do is you bring you can get a copy. Actually, we have a copy, so we can give it to you if you don't have it. A copy of the June 9th revocation of the emergency. And then there's, I think it's called temporary amendment to the Employment Standards Act regarding COVID-19. And that's the one that allows, or said it allowed an employer to put an employee on leave without pay. But that one expired on July 28th. So we have a copy of that also. So use those, and then you rely on the Employment Standards Act. Go through it, and you'll see there. Use your search, bring up every place where it says leave, and you'll find it's always the employee putting themselves on leave, and the employers have a say in it. Like they can ask for proof. Like if you're saying it's medical, they can ask for proof or some kind of confirmation from the physician that it's necessary. So I leave you with that. And I still think strongly that the progressive notices of liability have the best chance for success because you're getting after them right away. You can call them and you can hire. I don't think they take it on a contingency basis unless there's a judgment, but you can pay a collection agency to pursue the debt. And if it's whoever it is, you can also protest them. You can protest. They owe me money. They're not paying me money, especially if it's officials. Like if you're going after public health or bylaw or whatever, you can go to the city or wherever their location is and protest there. Put out a press release, at least on social media. I don't know if the media would touch it, but uh, the real media would touch it for sure. And there's a lot of good reporters out there that are giving good, fair coverage. So, there's and there we have one NOL that went into John Noble home regarding Harold and Alice, who were not able to see each other since this whole uh, so-called pandemic or plandemic began in April, or was it? No, it was March 2020. He was not able to be with his wife. He had Zoom calls and they weren't working. She has dementia and it wasn't working. But we did an NOL and also a phone campaign, phoning, like demanding that they allow them to have contact. And they finally caved in. And they're uh, the only situation that I know of that is allowing this. He's not vaxxed and he doesn't wear a mask. And he was allowed now, just as of this week, to take his wife out. He can take her either for a walk around with no mask on. She has to have her mask from her room to the door, but when she leaves, she doesn't have to have a mask on. And they can go also off in the car. So he's really, really happy. He met with her yesterday for the first time. It's emotional. The first time since March 2020. So NOLs do work. Direct pressure works, and we do have the capacity to push back. You don't have to say, there's nothing we can do. So unfortunately, we lost the power of the pre-judgment lien for these situations, except that possibly with the default judgment, which like I'm pretty sure you have a really good chance with employment, like when you're dicking around with your employment. But the other ones can still, they can have their credit rating affected because it's a debt. You can give them so long to pay, and if they don't pay, then boom, it's an adverse effect on your credit. So I'm going to leave you with that, and my final message is hashtag we got this.